Hello and welcome back to Take from Caesar. My name is David Merlin. Nothing you'll hear me say is intended as legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. I lack a little bit of inspiration that I had yesterday when I had attempted to make this tutorial. Because when I got done and made the MP3 of the audio file, today is Saturday, March 14th, 2020, and this strikes to Friday the 13th, yesterday when I tried to make the tutorial. The audio was an hour 15 minutes long, and then when I produced the video from screen capture software, it was only 28 minutes long. The software had shut itself down halfway into the video, and so the project was screwed. And I'll spare you all the inspired and enlightened rhetoric and diatribes that I dispensed in that video. We'll get to the point with the reason I wanted to make this Master of the Tax Code tutorial. And I'll cover it in much shorter order than I did in the previous version, the one that got all snafu'd. Now, some butt scrape, dog rape, puke, vomit monkey from the Patriot movement had this to say to me about a video of mine, David Champion and his book, Shattering the Myths, My Thoughts. And I revealed right in the video, these are my thoughts prior to even buying the book. And monkeys jump all over me and throw their feces at me, saying that it's a book review. No, it isn't. It's a reflection on David Champion and the reasons why I'd never buy a book from David Champion. I don't care what he writes, because he's incompetent. And I get this comment on my YouTube channel here, Take from Caesar. And I'm not an attorney. I can't give you legal advice. Understand, there's no such thing. When you get to court, all the Supreme Court cases you cite, all the federal appellate cases you cite, all the statutes relied upon, they don't matter if you seek to affect at all the standard operating procedures of the IRS. Every judge is in the pocket of the tax man, period. So up theirs, and up the tax honesty movement. Just screw the hell off. I get this comment 3 days ago. Again, it's March 14th, Saturday. If you didn't read the book, and this is from Truther1, right here, Truther1. What do you know about truth? They can't even see me. And so this is a video I've wanted to make for a long time, really. The Key to the Code video. You already have a video called Key to the Code, and I take you through key arguments, but I didn't use a particular document. I'm going to use in this tutorial to show you the master plan for my treatise of early 1994. The treatise that since 2006 has prevented no fewer than 15 indictments, nullified tax grand juries, shut down IRS criminal investigations, and all of this is lost on Patriot movement pukes. And just because David Champion studied for 20 years, it makes him right. I did what I did in 5.5 years. And the government can't even talk to you about, if you wanted to articulate every argument I found a controversy in, or that describes what I perceive to be a violation of the law on the part of the IRS, it's about 50 provisions. And they're in very particular categories of enforcement authority that simply take brick by brick the foundation away from what the IRS says is its authority. Brick by brick. Not one statute that does all the work. And David Champion ended up and stayed in Chapter 3, non-resident aliens and foreign corporations. Well, that's why I started my video, my tutorial about David Champion and shattering the myths, with the memorandum from a chief judge, U.S. District Court chief judge in North Carolina, written in 1992. 1992. He briefed his way out of the non-resident alien argument. And if you can't write and outright a U.S. district judge, you got no business making the argument. But it's not enough for David Champion, and he doesn't even claim to have been to court. I wrote 3 people all the way to the Supreme Court, ending in 2018. I wrote their appellate briefs. I wrote most of their tax court briefs of the 3 clients on appeals. 2 of them I wrote in tax court. And I wrote their Supreme Court appeal. So, been to court and been to court and been to court, and these are secret provisions I use. You can't have them. They won't talk about them, when in fact, in 1992, the non-resident alien argument was destroyed. And I begin the video called David Champion in his book, Shattering the Myths, My Thoughts. And this a-hole from the tax honesty movement thinks I was writing a book review. No, I wasn't. I was writing my thoughts about his book based on what David Champion has proven himself to be, incompetent. So here's the exchange, the comment left under that video here on Take from Caesar, and my response. From Truther 1, if you didn't read the book, then you do not know the subject well enough to be a critic. I'm not critiquing the book. I say that right in the video. David Champion did real research for over 20 years, and you are blowing in the wind like a trash bag. Sorry if you find my analysis offensive. Analysis of what? This is the guy's opinion of what I had to say about David Champion, wrongfully calling it a book review so he could throw his feces at me like a chimp. An anti-tax movement chimpanzee. You're the rappers of civic duty, stupid. Speaking of which, did you hear about the rapper that won the spelling bee? Don't be naive. And my reply is, what analysis? Shooting from the hip to justify chewing me out? Should have been a question mark there. I said his conclusions in the video I watched from David Champion were so damn stupid he proves he stopped his research too early and has solved nothing. Why read a book written by somebody who has already proven himself incompetent? Watch my videos on the tax honesty movement and shut the hell up, stupid. Because in my videos, Cult 1 and Cult 2, I shout down the movement as a bunch of monkeys that can't even see me. And yet they fill their hands with their feces and throw it at me when they don't know a damn thing. Same with David Champion. He solved nothing. His conclusions are void. Why would I buy his book when he's a proponent of stuff that I have to mock to keep people out of prison for following it? I keep people out of prison. Tax movement morons that haven't even been to court on their findings put people in prison. I've seen it and I've seen it and I've seen it. And so I argue only statutes and regulations that it's proven over time they can't even talk about. I got a bunch of Supreme Court cases and federal appellate cases where people challenge regulations saying, hey, this regulation from the executive branch conflicts with statute. And the courts rule as to whether or not the regulation exceeds the authority of the executive branch to implement the statute into law. You can't have that when I argue regulatory deviations from statute, because I found a few that are obvious deviations from statute. So I'm making valid arguments, and the courts refuse to even look at them. And they'll penalize you for mentioning certain statutes when, in fact, that's Congress. Marbury versus Madison and the cases that cite it say the judiciary's role in our Republican, in our democratic republic, say a constitutional republic, say that the role of the judiciary is to say what the law is. And they've never said it in any of the cases I've handled. 5 times to the Supreme Court by October of '98. In another century. And I don't care how many years of research Champion did, he's still making the non-resident alien argument, with full knowledge that it lands you with $5,000 per tax return, frivolous filing penalty. Frivolous tax return, 6702. And unless I say otherwise, I'm talking about tax statutes, 26 USC. And so I simply did more work. And that's what this video is about, is because another tax movement chimp crawled out of the woodwork. Truther1, go to his YouTube channel. He has no content. So he's not a guru. He doesn't do any reviews. He's got a name on YouTube. Big deal. I'm up to like 45 tutorials now. And like I said, I'm sparing you the rhetoric I put in the first version. And you can still tell how resolute I am to call this monkey out for what it is. It's a monkey. And I don't care how. I started the video about David Champion with the memorandum from that district judge. And what this monkey doesn't understand is that this is law. If I'm wrong, then you have a contrary memorandum of law. No, you don't. I got Dave Champion's videos. You have to spare me. They don't even know it. They're learning from people that are so stupid that they don't even understand that when you see a brief based on law, you have to disprove it with a memorandum of your own. It's called arguing the law. But instead they pound on the table. A very accomplished attorney told me, when you got the facts on your side, you pound on the facts. When you got the law on your side, you pound on the law. When you don't have either of those on your side, you pound on the table. And that's the tax honesty movement. It's not honest at all. How does Section 83 operate in your conclusion that a non-resident alien owes the tax or doesn't owe the tax? They choose to ignore it. David Champion says, Dave Merlin's ridiculous argument about Section 83. Where's your contrary memorandum? The government can't even provide one. The government doesn't even have an interpretation of a statute. Everybody agrees explains how to tax the entire workforce. And because he can't interpret one paragraph of tax law, Section 83A, he fills his hands with his feces and throws it at me. Patriot movement chimp. I've been watching it for 30 years. Yeah. And what I discovered, it only took me 5.5 years to do it. David Champion's going on 21 years, according to this monkey. So obviously, I'm abundantly more intelligent, learned, and diligent than is David Champion. And these people can't even, I use the term people loosely, this monkey can't even see me. And the monkey doesn't tell me, you're wrong about Section 83. Instead, he calls my thoughts about David Champion a book review. When in the video, I said, this is not a review of the book. I'm not going to buy the book. He's wrong about this argument, so wrong. He's hitting foul balls everywhere he hits a ball. Why would I buy his book? It's like buying a book about molecular science or nuclear energy from Michael Tyson. Why would you do that? You can't do anything but waste your money. Enough of my rhetoric. It's so obvious. The guy didn't even listen to what I said in the video. He has no contrary memorandum, so he has no knowledge of law or the practice thereof. When in fact, I've nullified tax grand juries and shut down IRS criminal investigations with statutes they refuse to speak of. Any questions? Wow. And you got the tax honesty movement saying, yeah, I got questions. And they just drool and crap all over the floor. It's why I avoid the movement like a plague. It's nowhere to be. You have to spare me. Okay, enough of the rhetoric. Almost. You'll still hear some. About the knuckle draggers. This is the burden of proof statute. The IRS and the courts have lived here forever. It's like the first statute you learn when you read about the tax code in publications from private individuals. Private individuals, 19 1988. I was given a binder of materials from the Golden Mean Society in Condon, Montana, Peggy Christensen. And I got into it. I read everything, and they were strong on the Fifth Amendment. You can't make me incriminate myself by putting my personal information on a tax return. I'm not the definition of employee in Chapter 24. And they were not arguing non-resident alien status. They were geared toward interpreting statute. Great. That's how I got my feet wet. And then here comes non-resident alien arguments, 1991. And by, early summer of 92, I had my 1040 NRs all filled out, and I was ready to file them. And that's when a reign of horror poured over the tax movement in the form of frivolous filing penalties. $2,000 for every tax return you file as a 1040 NR. And I said, this is no place to be. And I turned my back on the movement. Shut them out entirely. One of the best decisions I've made in my entire life. One of the worst decisions I made in my entire life was, hey, I'm going to get into the law because I thought it mattered. You know, Pledge of Allegiance, liberty and justice for all. Horse crap. It's child abuse. It's a false, it's a falsehood. It's a lie. Because you can't even sue for clear explanation of tax statutes that govern. U.S. versus John Steele. U.S. District Court, Kentucky. Counterclaim he filed against the government demanding clear explanation of the laws. And his counterclaim was dismissed. You can't sue for clear explanations, even though the government refuses to give them to you, but in the Taxpayers' Bill of Rights it says you're entitled to them. Helvering versus Texpan Oil Company, 1937, says so as well. So here we have everything is gross income in statute, and they refuse to acknowledge that the first sentence is, except as otherwise provided in this subtitle. We aren't going to hear it. There are no exceptions. Everything is gross income. And we're penalizing you thousands of dollars for thinking it's not. That's how they overpowered this phrase, except as otherwise provided. Compensation for services, fees, commissions, tips, fringe benefits, similar items, and gross income derived from business. That's self-employment. So everything's gross income, except as otherwise provided. 61B, for items specifically included in gross income, see Part 2, Section 71 through 90. I think Section 83 is in there somewhere, don't you? But we won't talk about it. You can't have it. We aren't going to discuss it. We have no interpretation of it. We're public servants. We don't have to look at the law. You lose. And here's your penalty for thousands of dollars. Those are the rules. Every judge is as corrupt as the day is long. Without the judiciary on their side, the taxman loses. The IRS loses. The DOJ loses. But since the judge is owned in full by the taxman, you lose. And we don't have to talk about it. We're public servants. It's that bad. I've written 2 lawsuits. South Carolina, 2, South Dakota, Texas, tax court, Florida, tax court, Indiana, and the appeals on the 7th, 9th, and 11th circuits, and the Supreme Court briefing from the 7th, 9th, and 11th circuit losses in just the last 5 years. You can't have the law. They won't talk about this. Here's the way I argue the law. It happens to nullify tax grand juries. It happens to shut down IRS criminal investigations, but in court, when there's no jury at the end of the rainbow for you, you lose. They'll still lean and levy you. Here's the goods on Section 83 in the footnotes. Anytime you want to read this, pause, because I'm going to cruise through this document. This is a quote from the Fifth Circuit, 1992. This is the first sentence in the opinion of the court. Section 83A explains how property received in exchange for services is taxed. It explains how to tax the workforce. It applies to all compensation paid for services of corporations and for services of individuals. Footnote 2. Labor is property. Footnote 3. The fair market value of property is established through the terms of an arm's length transaction. Footnote 4. Black's 6th edition arm's length transaction. That definition is on page 109 of the dictionary. And here we have quotes from cases about Section 83. I shut out the movement, started reading at page 1. When I came to Section 83, I said, if this applies to me, it's not being enforced. The damn statute is called property transferred in connection with the performance of services. What do they have to call it? Paycheck City to get somebody to look at it? When I saw it, I go, holy smoke. And it's true today. It's not being enforced. They'll penalize you for asking about it. And here's more quotes. This is pretty interesting from 2nd Circuit 2011. At the heart of this case is Section 83, which governs the taxation of property transferred in connection with the performance of services. That's not enough for David Champion. Revenue Ruling 2007-19. This is the IRS in a revenue ruling. Section 83 provides for the determination of the amount to be included in gross income when property is transferred to an employee or independent contractor in connection with the performance of services. This isn't enough for the tax honesty movement. They can't hack it because they can't interpret 83A. One paragraph of tax law totally confounds them. And I'm supposed to buy their books? Are you stupid or something? I think that's a quote from Commander Spock on Star Trek. We have referred to the Court of Appeals when inquiring whether a right was clearly established. Right. You cite appellate case law. That's clearly established law. It doesn't have to be a Supreme Court decision. Read the case of David Lanier, Tennessee Chancery judge, hearing divorce cases, and would invite the women from the divorce cases into chambers, saying, you might need a job at the courthouse here, or let's discuss custody of the children. And he took to orally raping them up against the door of his chamber. The indictment was brought for violations of 18 U.S.C. 242, which carries only 1 year per count, and he argued void for vagueness. This statute that prohibits a violation of somebody's rights based on a class discrimination, meaning their gender, in this instance, it doesn't tell me in advance that raping these women violates their rights. And the district court said, the statute is void for vagueness. And the government appealed, and the Sixth Circuit said, there's no Supreme Court case on this that would sufficiently advise him that his conduct offended this statute. And so 2 women from the Department of Justice appealed the case to the Supreme Court, and the Supreme Court said, whoa, this is a different standard than we've seen before. You can rely on appellate decisions. You don't have to have a Supreme Court decision in advance of some act to determine that it's unlawful. And the Supreme Court was brutal about it. They said just because we haven't seen a case here in the Supreme Court on a child welfare worker selling children into sexual slavery doesn't mean it's not a violation of law to do so. Good point. So the guy fled to Mexico. The Fed had to go down there and arrest him in Mexico and bring him back. And then from prison, he filed a bunch of habeas corpus actions, dredging up the same issues. Real seedy dude. And so I love to cite that against judges, saying, I know judges. And on the Sixth Circuit, where they cited Sixth Circuit case law saying you can't have clear explanation of the laws, I said, is that the same Sixth Circuit that said it's legal to rape women in chambers if you're a judge? That's pretty inconvenient. Here's a quote. You want to stop the video and read this. Okay, this is from Talmadge versus Commissioner, 1995. In November of 95, he stood in tax court, I think it was South Carolina, and said, I'll concede all facts of the case today if they'll just tell me how to comply with Section 83. And so they penalized him $6,500. And he got no explanation. This is the best they can do. They didn't get into the language of Section 83. It was argued, but the regulations under Section 83 say my cost is the value of any money or property that I paid. Where's your authority to exclude labor or property within which I have no basis from this regulation that says any property is a cost? $6,500 penalty. We aren't going to talk about it. Father of 4, UPS driver with a wife at home, and got penalized 6,500 bones because he dared to challenge the IRS under Section 83. So as early as 1995, they started racking up victims of this policy that the law is off limits and we don't care what the law says. And here's the appellate court decision. I wrote this appeal, one of the first appeals I wrote in my life, and they said, we affirm based on the reasoning of tax court. So, same decision in tax court is what counts here to justify the penalty. In the minds and souls, which are toilets, of the Fourth Circuit Judiciary. And here's the statute itself. At any time you want to read this, pause the video because I'm going to cruise through this. Here's 1.83-4B2 that says you have to apply Section 1012 to figure your cost. Well, we just tried that and got penalized. Can't have it. 1012 says the cost is the amount paid in cash or other property. It doesn't say cash or other property except labor. U.S. versus Monsanto. Monsanto, a heroin manufacturer and distributor, got busted, and under the Civil Forfeiture Act, they seized all of his money because the act says any assets tied to the conspiracy and distribution of illicit drugs. And he said, hey, you got to leave me enough for attorney's fees. And the Supreme Court in 1989 says, well, there's no exception in the statute for the assets used to pay for attorney's fees, or anything else for that matter. There's no exception in the law. And from the Robert Orth case, Seventh Circuit, the tax court decision was October 12th of 2017. They said there's an exception under a general rule that wages are gross income. So you're taxed under a general rule. The general rule is the exception, not a statute. And here the Supreme Court says there's no exception in the statute, the civil forfeiture law. And so we're taking all your money and you don't get attorney's fees reserved from the cash you had on hand. Again, if you want to read this, pause the video. And 1012 leads to 1011, which leads to 1001. And the conclusion is the amount that remains after the adjusted basis, which is the cost defined by 1012, has been, after it's been restored to the taxpayer, what's left constitutes the realized gain. I have no realized gain because I excluded from gross income the value of my labor. Well, you can't do that. Why can't I, Your Honor? It's going to cost you thousands of dollars. How dare you ask us to answer a question at law when the role of the judiciary is to say what the law is? Any money or property paid is your cost. The value refers to the value of any money or property. What's the value of your labor? It's determined through the terms of an arm's length transaction, as we saw, which is a transaction negotiated between unrelated parties acting in their own best interest under no compulsion to buy or sell, all relevant facts disclosed. And here's the quote of the argument against Section 83 in U.S. versus Warner, a tax criminal trial for tax evasion in Alaska, 2008. I wrote the motions. And here's the best they can do to argue against Section 83, a bunch of tax protester cases. And here's the part in the motion where it says, begin the relevant part, the part that's relevant to Section 83. This is the best they can do. And they cite case law where Section 83 wasn't even in evidence. 1012 wasn't in evidence. The argument that they are not gross income has been rejected so frequently that the very raising of it justifies the imposition of sanctions. It's a statute. Well, we don't care. Wow. The argument that payments for services, that's not what he argued. He argued that he had been deprived of the provisions of Section 83, and they don't even get into it. So every judge is as corrupt as the day is long. Every single judge stands between you and the law. And so I call them baby rapers. I will in open court. You bet. I can't have the law. You won't discuss the law. What a baby raper, Your Honor. Servant breath. They stand for this. And you can't have the law. And they cite an ocean of case law that was developed through the stupid litigation tactics and understanding of the anti-tax movement chimps and gurus. So you're up against an ocean of case law that they use against you to get around the law, when I'm arguing pure statute. To tax my pay, you have to deprive me of the provisions of Section 83, 212, 1001, 11, and 12. Oh, we can't talk about it. And you lose. But we shut down criminal investigations at the IRS. We nullify tax grand juries, my partner and I. But when they're after your money, or when you raise them after they get the indictment, you lose. And they're not going to talk about it. And you think you have courts? This is not a country. The 4th of July is civic masturbation. Hey, we got a country. Shoot off fireworks. You're the personal possession of a hate group you call government. This is not a country. It's an open sewer surrounded by razor wire. If you think it isn't, go through all the cases I've written. You can't have the law. And they can't even deny that, in fact, the law operates the way I've briefed it. They don't have a contrary memorandum. I've been to court and been to court and been to court, written and written and written against the government's best, the government's best, the government's best. You can't have it. So every U.S. attorney, every assistant U.S. attorney, and every judge, when they're not raping children, they're catching their breath. Pause if you want to read it. This is a discussion of what they said in Talmadge. This is a very important case here, 1974, Fourth Circuit, where the law is vague or highly debatable. A defendant, actually or imputedly, lacks the requisite intent to violate it. That's a definition of innocence. No criminal intent. 29 cases since this case have cited Kreitzer and this phrase. So, the law is vague or highly debatable. It's not debatable at all. They won't even talk about it. So how could you say somebody has criminal intent? We can say that because we lie to grand juries. We're public servants. Wasn't that easy? Clear, simple answer to that very basic question. How do you do that to people? Oh, we lie to grand juries so that we can send innocent people to prison. Make no mistake about it. Okay, these are cases about that the government won. There's only 4 of them here. There's been one since I wrote this document, 2008, Ali versus Federal Bureau of Prisons, where the government argues the term any is all-inclusive unless the law contains an exception. And they won 5 cases arguing that way. Pause if you want to read it. Here I go. And this is a quote from Monsanto again. Pause if you want to read it. And then we have the more of Monsanto. Pause. And now we have an excerpt from U.S. versus Gonzalez, 97, where they say the same thing. Any means all of it, unless the law makes an exception for something. Because Congress writes the law, and the judges will say in hundreds of Supreme Court decisions where the argument is clear and the statutory language is unambiguous, the argument's over. We can't read anything into it. We're just the judiciary. All that flies out the window when you beat the tax man with the law. Make no mistake about it. And here's the end of the excerpts from case law on the term any property. And here are appellate cases. And U.S. District Court, let's see, right here, District of Columbia Appeals. I think there's a Northern District of Ashland, Kentucky, U.S. District Court number. All of them agree, any means all of it. And that was a quote from Rubio versus Lynch, 5th Circuit of 2015. And U.S. versus Porter, 10th Circuit, 2014. All these cases say any means all of it. And when you go up against the government with any in tax law, they say, oh, we go by a general rule that wages are gross income. After they tell you statute governs, Section 83 explains how to tax the workforce. Not in this case, the general rule does. So there. Don't forget it, citizen breath. The servants are in charge of you, and they don't need the law. Void for vagueness. There's a very interesting and sweeping quote I want to point to in this little exercise of void for vagueness. The hardest thing in the world to understand is the income tax. That's Albert Einstein. They don't say on the IRS's website when he said that, but that's good enough for me. And he might have been looking at the 1939 tax code, which was 1/50th as complex as the tax code they put out in 1954. Congress did not write it. Compare the tax code to all the other titles, and the first conclusion I reach is that, Congress did not write this. You look at all the other titles, and the tax code stands out as a monstrosity of complexities. Now, right here, and this is all about tax must be imposed by clear language or the taxpayer wins. Read these cases. I did. That's why I cite them. But look at this one. It is a fundamental tenet of due process. That's the Fifth Amendment. It is a fundamental tenet of due process that no one may be required at peril of life, liberty, or property to speculate as to the meaning of penal statutes. But the law is a secret and will send you to prison. Ah, okay. So there's another group of Supreme Court cases that simply fly out the window after the courts wipe themselves with it and discard it, and you go to prison. A criminal statute is therefore invalid if it fails to give a person of ordinary intelligence fair notice that his contemplated conduct is forbidden. But we aren't going to talk about the law, and you can't sue for an explanation. So how, and that was U.S. versus Batchelder, footnote 11, 1979. Why isn't that good enough when you get to court? Here's another good one. This is a Supreme Court decision saying that the government has to explain statute, it has to be clear enough, and they cite a state case, Level versus Blades. When the tax gatherer puts his finger on the citizen, he must also put his finger on the law permitting it. No, he doesn't. We're public servants. We don't have to honor any of that, and you go to prison. I prove it, I prove it, I prove it, I prove it. This is a 2001 Supreme Court case. United Dominion versus U.S. Lowell B. Craft brought this to my attention. Fantastic quote. He must put his finger on the law allowing. We don't have to do that. We're public servants. And they don't. They don't put their finger on the law. After telling you Section 83 governs, they won't talk about it, and you go to prison. It's a hole in due process. These excerpts are from cases, very recent cases, about criminal intent is a part of every criminal statute. And so you want to be on record with a good faith explanation of the law, even if unreasonable. It means you're not willful. This is the essay portion of the exercise. Pause if you want to read it. I think you should. So I'm arguing the heck out of the void for vagueness doctrine and lack of criminal intent here in this essay portion, and citing cases from which the quotes are excerpted. Taxpayers were entitled to know the basis of law and fact on which the commissioner sought to sustain the deficiency. Helvering versus Tex Penn, Supreme Court 37. That's a lie. This is an interesting quote from Hartman versus Commissioner Tax Court 75. But the Internal Revenue Code cannot be so read, for each section is not a self-contained whole, but rather a building block of a complex, interrelated statute. So it's always going to be an equation of governing provisions that bring you from the receipt of what they say is gross income to the point where a tax is imposed upon what's left after allowable deductions. This is a Lowell B. Craft victory from 1998. Got the guy a new trial. The Eighth Circuit said, for the foregoing reasons, we conclude that one accused of tax evasion must have the opportunity to prove, however unlikely the proposition may be, until I did my work, that an administrative final tax assessment does not accurately reflect the existence of a tax deficiency. Therefore, Silkman is entitled to a new trial at which he may introduce evidence relevant to whether there in fact was a tax deficiency. No, he can't. Not Section 83. We won't talk about it. So when you beat the government with the law, it's an exception to all standards of due process. Period. Conclusion. What the government does not deny about Section 83, they can't even talk about it. They don't deny a single thing I have to say about Section 83. The burden of proof is Section 61A, except as otherwise provided. So if you can't prove an exception, then everything's gross income. And then when you do prove an exception, you get penalized thousands of dollars. But when you introduce evidence to the contrary prior to a criminal case, even during a criminal investigation or during grand jury proceedings, it shifts the burden of proof. Portillo versus Commissioner, Tax Court, I think it was 95. The presumption of correctness enjoyed by the Commissioner of IRS disappears upon introduction of evidence to the contrary. A determination is a consideration of all relevant facts and statutes. Government won't cite Talmadge. Why? You beat the hell out of Talmadge, $6,500 penalty. But when you raise Talmadge in your briefing, this is 2017, Tax Court, Robert Orth versus Commissioner, they won't mention Talmadge in their rebuttal because he made the challenge. Where's your authority to exclude labor from any money or property paid? And they can't talk about it. So why didn't you cite Talmadge? The government refuses to mention provisions relied upon. On the Seventh Circuit, full briefing. And the government didn't even have to mention any of the statutes relied upon, and they won the judgment. And the court didn't mention the statutes either. An ocean of bad case law due to the complexities of the tax code and the stupidity of the tax honesty movement, then known as the Patriot movement, the anti-tax movement. They got to keep changing their names because people that really know what they're doing throw their feces back at the tax honesty movement. So they got to change their name. No excuses for H&R Block, CPAs, tax attorneys, the IRS, and others. No excuse. These are statutory arguments. What is an expert? Repeat after me. I'm a big bad attorney. I'm a CPA of X number of years. I represent people in tax court and in audits because I'm an enrolled agent to the IRS, but I don't know anything about the statute that explains how to tax the workforce. Is that an expert? Now we're to the beef. This is the beef. Look at all these provisions. From these provisions, I can probably make 8 or 9 statutory arguments. And those are the heart of my 1994 treatise. And we're talking the first quarter of 1994. I was done. 5.5 years work on the entire tax code. And so you can't imagine what the key to the tax code might look like until you see something like this. And then you look at David Champion and you see that, oh, he's the master of 2 or 3 statutes, just like Irwin Schiff, just like Glenn Ambort, Larkin Rose, and Eddie Kane. Non-resident alien, Section 861. And then you see in the video on David Champion that I put out about shattering the myths, I start with the memorandum that destroys that argument, where they look at the entire world of taxation through a single statute. These are the provisions that you'll find in the briefings that I do against categories of enforcement. Chapter 1 taxation, the individual income tax and capital gains, the brackets, the graduated income tax. Chapter 2, self-employed Social Security. Chapter 21, employee Social Security. Chapter 23 is the matching FICA that employers have to pay based on what they make you pay under this chapter. And Chapter 24, federal withholding. And then the places in procedures and administration where I feel I've identified violations of the law, compromise of the law through regulations that twist or omit very important portions of statutes. That's the key to the code right there. Look at all those provisions. There was a time when I could quote you verbatim all of these, This is a 1995, maybe 1994 document. How about that? So in 5.5 years, I did this and wrote a string of arguments in a curriculum, and then wrote the first briefs of my life in late 93, and then made this document probably in 1994. And yet you got the tax honesty chimps with hands full of their feces thinking they have a take on the tax code and they should spout off to me. Because David Champion is utterly incapable of interpreting Section 83A, he calls it David Merlin's ridiculous Section 83 argument. Get to the part where I'm wrong. This is law. You have to have a contrary memorandum. Well, I don't. I have a book. I've never been to court and never written a brief. I'm David Champion. This is why I throw it right back at the movement. They refuse to learn. Some of my work they wouldn't even be able to understand, when in fact by spring of 94 I had probably already read 1,500 or 2,000 federal appellate and Supreme Court cases and tax court cases, and just picked them apart. And from that you gain an understanding of how you have to approach the task of interpretation of statute and regulation. They don't have that because they haven't done the work. So from this comes several arguments. Here's the argument about citizens of the U.S. are only named in a regulation. The tax code's never been written to apply to citizens of the U.S. Issue A and B. Issue A, is 4 U.S.C. 72. All offices attached to the seat of government shall be exercised within D.C. and not elsewhere unless expressly authorized by law. These 3 chapters are Social Security. And I knew of the definition of citizen in these 2 chapters, and they expressly exclude citizens of the United States, which the government says I am. Okay, let's take that. Yeah, that's me. Sure. And so I attacked these chapters based on that. And what did I find when I went through the entire tax code, the relevant chapters, looking for affirmation that citizens of the U.S. are excluded from Social Security? And I went through the tax code like twice, looking for indications that in fact Social Security was meant only for citizens of the possessions. Just Social Security. It's not a Chapter 1 argument where they say citizens of the U.S. owe money. They just get you on this through complexities and steamrolling you, sandbagging you. But in 42 U.S.C. 411 B2, the Social Security Act of 1935, Section 211, both have the same definition of citizen that you find here in 1402B, self-employed Social Security. That's not me. And as I cruised through the tax code, I found 7651 5A. In 2007, above 5A, they omitted a provision, so now it's 4A. This one moved up. 76514A says, any reference in Section 28A of the Revised Organic Act of the Virgin Islands to any tax imposed by Section 3811 of the Internal Revenue Code shall be deemed to refer to Chapters 2 and 21. So I went to Section 3811 of the tax code. It doesn't exist. I thought, the Virgin Islands have been around a long time, a lot longer than the 1954 tax code. So I went back to the 1939 tax code, Section 3811. Collection of taxes in Puerto Rico and the Virgin Islands. A, Puerto Rico. B, Virgin Islands. In 1954, they simply split that statute up into Chapters 2 and 21. The government can't even talk about it. Section 7655 says for taxes imposed in the possession, see Chapters 2 and 21. Over here in Chapter 1, you got 879A2 that says to figure out a non-resident alien spouse's share of distributorship income, go to Chapter 2. So in Chapter 1, they kick a non-resident alien to Chapter 1, which is a citizen of the U.S., into Chapter 2, meaning Chapter 2 is for people that are non-resident alien to the citizenship possessed by the person in Chapter 1 that they say I am. And that would include a Puerto Rican. They have a different citizenship. They live in a different land. They are non-resident alien to my citizenship, not to Washington, D.C. I'm not making the patriot movement monkey argument. And I explain all this at a whiteboard in the video called IRS Tax Whistleblower, Tax Code from the Ground Up. Watch that one. There's 2 videos at present on my YouTube channel where the picture or the banner, the placard above the description of the video is the IRS in SWAT uniforms at the front door with rifles. There's 2 videos that have that picture. One of them is Tax Code from the Ground Up. Watch that video. This is what I do in that video. I'm showing the document from 1994 that explains what I do in that video at a whiteboard in 2003 when I was teaching to a group here in Seattle of about 10 people. So when I went through the tax code, I found a bunch of indications that Social Security is just for the possessions, which leaves us with just Chapter 1. Okay, Chapter 1, Citizens of the U.S. You have Section 1 of the tax code, tax imposed, and all the tax brackets. Section 1H is capital gains. But nowhere does Section 1 mention anyone's citizenship. And so they wrote a regulation, 1.1-1C, that says citizens of the U.S. owe this tax wherever they live. And so I challenged that regulation because it deviates from statute. Statute is Congress. Congress didn't say citizens of the U.S. owe this tax. And they'll penalize you for asking. The Seventh Circuit in U.S. versus Vallone, was it 2012? Seventh Circuit Appellate Court says you are not a non-resident alien, you're citizens of the United States, and you owe this tax. See Section 1 and 1.1-1C, the regulation, the IRS regulation that identifies the subject of the tax. Really? The Seventh Circuit says it's the regulation that identifies the subject of the tax? And that was raised as a point of contention in Robert Orth's Seventh Circuit appeal in 2017. And so the court itself on the Seventh Circuit said the regulation identifies the subject, but when you tell the court only the regulation identifies the subject of the tax, they'll penalize you $4,000. And they won't talk about it. You don't catch flack unless you're over the target. So no one can challenge this regulation as a deviation from the statute. Statute does not mention citizen, and the regulation does. So Social Security is obviously never written to apply to Americans. These definitions of citizen expressly exclude citizens of the United States. And this one, citizens of the U.S. are implicated solely through regulation, and the government can't talk about it. Section 83. There's a lot of provisions here. Watch the video where I stand at the whiteboard. I'm not going to go over all these. There's a couple of particular note here, Section 31A and B. Section 31A provides that the Chapter 1 taxpayer can get a credit for the amount withheld over the year from their paychecks through the W-4 form. And Regulation 1.31-2B says only the federal public servants, this employee in Chapter 24, are eligible for that credit, and yet the whole country takes that credit on their 1040 EZ. Oops. 31B says the Secretary can write regulations under 6413C for a credit of FICA. And an enrolled agent to the IRS, certified paralegal, went and chased this down and said, yeah, it's only for public servants, this credit for FICA, if you had more than one employer during a taxable year. Now, if Section 83A applies to this self-employment income and these 3121A wages, why don't 63C and 151D also apply to that compensation for services? Standard deduction and personal exemption. It's up to $10,500 now, I think, that are excluded by exemption not as a cost, but by exemption from calculations of gross income, or taxable income, excuse me. Why, if Section 83 applies to this, don't these exemption statutes also apply to this? How come they take FICA right off the top of my paycheck and I don't get a deduction under those two statutes in Chapter 1 when in fact Section 83 applies to all of it? Fascinating. 1.83-3G, the amount paid is the value of any money or property. That about covers it. The 1939 tax code, Section 111, 12, and 13 are the origin of Section 1001, 1011, 1012. 26 CFR 601.106, the law must be strictly adhered to with indifference as between the taxpayer and the government. Horsepucky. 6673, definition of the term person. 6702, definition of the term person. This one is about tax court petitions that are frivolous. This is about tax returns that are frivolous. This is about the definition of the term person in the Chapter 75 on crimes. The term person includes, and so they enforce it as an inclusion instead of as a definition. It includes everybody, and even these people that are mentioned, but it doesn't mention you or me. For the purposes of this subchapter, the term person includes any officer or employee of a corporation or member or employee of a partnership who, as such officer, member, or employee, is under a duty to perform the act with respect to which the violation occurred. Well, that's not me. They say my duties arise from having received gross income, not from being a member, officer, or employee of a partnership or corporation. We don't care. It's an inclusion. Everybody. 27 CFR 70.150B says the value of property is calculated under the terms of an arm's length transaction. Hallelujah. Social Security. Here are all the provisions relative to my Social Security analysis. Here's 879A2 that says a non-resident alien spouse distributorship share of income shall be calculated under Chapter 2. Okay. And then we have this one. A regulation, it has a decimal in it. It's regulation 1.1402A-2A. Figure this tax using Chapter 1 provisions. So non-resident alien to Chapter 1 citizenship, U.S. citizenship, pays the Chapter 2 Social Security tax, but they use Chapter 1 provisions to figure it. How come they don't get the deductions? It's taken right off the top. Same with Chapter 21 employee. See how that works? I do. And then 602.101 is a nightmare. It's a collection of numbers written by the Office of Management and Budget explaining in relation to particular regulations, and I mean a million of them, what is the OMB number that is to be found on the form relevant to that regulation. You have to look at that regulation to understand that the law is against you. There are complexities so deep in certain places that you'll never get out of them. But if you went to this regulation right here, 31.3121E in 602.101, you're going to find OMB numbers that aren't on any of the forms ever used to tax your paycheck. And I'll bet you it's because this employee is entitled to these deductions, which you do find on the Form W-4 and its OMB control number, which means there's $10,000 of your pay annually that you don't owe FICA on, but they steal 7.5% of it anyway. That's $750. And here we go. The argument about voluntary compliance. If they can't assess you because 6201A says they can assess stamp taxes, well, I'm not a stamp tax payer. That's foreign insurers and casinos. So they wrote this regulation under 6201, and it doesn't even use the term stamp. We can assess all taxes imposed by the 1954 tax code. So you challenge that regulation, they'll penalize you thousands of dollars. Section 3640 of the 1939 tax code says the same thing as 6201A. Stamp taxes. Don't let anybody tell you that it's ATF, alcohol, tobacco, firearms. You go to the index and you look up stamp taxes, and it'll say 4300s and 4400s of the code. Foreign insurers and casinos. So don't let a patriot movement chimp misguide you. 601.106, the law must be strictly adhered to. 6671B, a definition of the term person, any officer, employee, or member of a partnership or corporation. 6673 is in that chapter, frivolous tax court petition. Doesn't apply to individuals. Oh, but it's an inclusion. It's not a definition like Congress calls it. So don't get sucked into thinking you'll get a definition enforced as if it were one. It's always enforced as an inclusion. 6702, same thing. 7343, same definition of the term person, but they enforce it as an inclusion and not as a definition. Provisions relied upon. There they are. Provision number 1, 2, 3, 4, 5, whatever, in this 13-page document. So you can read as I go through this. If you want to read those provisions, pause the video. But here they are. This is a 1995 document, maybe 1994. And here's that list of provisions. And you can't have them. These are the secret provisions. Nobody will talk about them. The courts refuse, and they'll penalize you thousands of dollars for trying. And in this list is going to be one, of note, 601.106. I do the statutes first and then the regulations. Here's the 1939 Code Section 3640. They can assess taxes where such taxes have not been duly paid by stamp. I don't pay my taxes by stamp. They take postal money orders. And here's the regulations, the second part of this publication, this 13-page portion of my curriculum from late 94, early 95. I was heavy on the job, full time. In a nutshell, this is an abstract of primary claims. This is a reflection on enforcement based on my findings. From this angle, from that angle, from this angle over here, and from that angle, and looking up and looking down, looking left and right, different ways to look at enforcement compared to my findings. Pause when you want to read this. I apologize if the print is small. If I make this document available, the address to this document on the web in PDF format will be in the description of the video in the text underneath the headline of the video on YouTube. Take from Caesar. Why I don't owe Social Security. Why I don't owe Social Security on my salary, wages, self-employment earnings. And then I reflect upon the provisions relied upon and not upon some theory. Why I don't owe Chapter 24 withholding. Why I don't owe income tax Section 1. Why I don't have to file. And if they can't assess you because you don't pay taxes by stamp, it's pretty much voluntary, isn't it? But they wrote a regulation to get around the stamp tax confinement or constraint on IRS authority, saying we can assess all taxes, and they don't even mention the term stamp in the regulation. Can't tax me this way, can't take my pay, can't do this, from all these different angles reflecting on the provisions in the list of secret provisions. If you want to read this, pause, because I'm not going to stop. In a nutshell, there's my curriculum in full, reflected upon in several ways, explained meticulously, and then crunch time for this in a nutshell document. And I wanted to show you this because this chimpanzee, Truther 1, threw its feces at me when they can't even see me. Look at the mountain of valid conclusions I wrote from only 5.5 years worth of work. And this guy says because David Champion did 20 years of real research, and it wasn't real research. He won't even look at Section 83, knowing full well it explains how to tax the entire country, non-resident, alien, and citizen alike. Period. That's not real research. He's not a real analyst. He's a monkey with his head in his ass. So, shut the hell up, anti-tax movement. You can't even see me. And look at the mountain of provisions I just guided you through. Watch my video called Tax Whistleblower, Tax Code from the Ground Up. Go watch it. And there, obviously, from the top of my head, barely with any reference to notes whatsoever, I explain all of this on the whiteboard. You had your chance to view it. Instead, you fill your hand with feces, your own feces, and you throw it at people. And I'm supposed to have a moment for you? I began the video on David Champion with the briefing from the U.S. District Judge in 1992, where he destroyed the non-resident alien argument. David Champion doesn't brief his findings. He doesn't go to court on his findings, because then he'd learn that no matter what you argue, the court's going to wipe itself with you. But if they can mention statute, like they did against the non-resident alien argument, but they can't mention Section 83, that's called validity. They can't even play the science of law against you. They simply have to pull out their authority and fondle it in public. That's their only out. Hey, I'm a judge. You have to do what I say. Yeah, but is it based on law, Your Honor? Well, that's going to cost you thousands of dollars there, Citizen Breath. So, the movement can't even see me. And because of this comment on YouTube, I had to pull out all the stops. We're going to do a master's course right here. And all I did to reflect on this was what you saw on the screen. I don't have a set of notes on the side. This is a fingerprint. I know it like the back of my hand. And I have since 1993. It was in my curriculum before I wrote the first briefs in my life. Watch the video that I have on YouTube called Shove This Regulation. I was that good, that knowledgeable, that astute before I even wrote a brief. I wrote a curriculum about my findings. The IRS wouldn't talk about those provisions. I said we're going to have to litigate. And I got some volunteers that took a bunch of it to tax court, 5 times to the U.S. Supreme Court by October of '98. What has Dave Champion done? I didn't hear him once say he's been to court on any of this. Where's your memorandum, Mr. Champion? Forgot that part. I just stand out here and charge $150 for my book. Well, I'll tell you what, with the coronavirus, toilet paper is flying off the shelves. You can't even find toilet paper. So when I need toilet paper, I know I can buy David Champion's book. Because that's all it's worth to me. It's all it would ever be worth. But there may come a time when, I don't care what it costs. I need toilet paper. So anyway, my name is David Merlin, and that pile over there that steams and stinks is the tax honesty movement. 2 different articles. And I teach truth. So just shut the hell up, all you gurus. You can't even see me, as proven by this tour through the key to the code. No one would have guessed what it looks like. Well, this is what the key to the code looks like. When you responsibly, thoroughly, and exhaustively research tax law, statutes and regulations, constrained by the canons of statutory construction and interpretation. Again, I'm David Merlin. I'm proud to give you truth like this. I want you to know the truth from somebody who's been to court and can prove that these findings pull the pants down on the U.S. attorneys and nullify tax grand juries and shut down IRS criminal investigations. So, with that having been said, I hope you're wiser. I hope you're smarter. I hope you stay out of prison. And the best you can do is start a home business and gather all the deductions H&R Block confirms you'll get away with at the end of the year. Stay in the system. You're up against a government that doesn't care about the law. Why would you start a relationship with a government like that? You got family. You got children that rely on you. And as soon as you're indicted, they're going to hold you pending trial. And now your family's you're reliant on your family. Instead of you being a breadwinner, you're a beggar in oversized boxer shorts and a great big orange jumpsuit. And all your friends will laugh at you, and your reputation, your mortgage, your marriage, your bank account, everything goes down the tubes. Why would you commence a relationship with a government like that by poking the beast in the eye? Just don't. And that all goes for Pete Hendrickson too. Thanks very much for listening, and I'll see you in the next tutorial here on Take From Caesar. I appreciate your consideration.
It was all bullshit.